Oh my. Um, Drew Clinton, after he was arrested by the police, he was 18 years old in 2 weeks. He didn't have a family or friends to call. He didn't call a lawyer. He went with the police and he told them and spoke with them at length after waiving all his Miranda rights. And the story or the version that he told them was consistent through a 4 or 5 hour interview in front of several very experienced detectives where they did the usual interview, the good cop, the bad cop, the it'll go better for you if you tell us what's going on. And he literally told them everything, and it was consistent throughout. He also told that same, made that same statement at trial when we made the decision to allow him to testify and expose him to cross-examination by a very experienced prosecutor. So the one thing about Drew Clinton is he has always made the same statement, and I've always taken the position that if you tell the truth doesn't change, you won't have a problem. And I think that helped him out in the long run a lot here because he was able to be consistent and tell the truth. The issue has always been one of consent. Did the young lady consent to the sexual activity that occurred in the basement that night? The evidence was very simple. She stated and that they were in the room, or excuse me, the evidence showed they'd been in this room for 3 to 4 hours. There was a little discrepancy as to what time they got there, but everybody agreed they'd been in this room, in this basement of this home for 3 to 4 hours. Her testimony was consistent in that she didn't remember what happened. It wasn't that she didn't know, but that she didn't remember. So the state had no evidence as to whether or not she consented or not because she couldn't remember. Drew Clinton, on the other hand, had always told the same version was, yes, she consented to the activity, she participated in the activity to a limited extent, and therefore he shouldn't be found guilty of the crimes. With regard to the first 2 counts, those were clearly rebutted by the three DNA experts who all testified that there was no semen found anywhere through an extensive examination of the young lady. And so I think that's what took care of the first 2 counts. The third count, the issue of consent, was what mattered, and I think it was the fact that Drew had always been honest with everybody that helped.
What is Drew's feeling on the judge's reversal? What is Drew saying about the judge's reversal?
Well, Drew Clinton's an 18-year-old boy going on 14. He's probably one of the most naive individuals I've ever represented. He's also a very pleasant young man. I think he's overwhelmed by, I know he's overwhelmed by everything. He was overwhelmed by the arrest. He's been overwhelmed by the whole process that he went through. I think he was, I don't want to say destroyed, but he was very upset with being found guilty of even the 1 count. And when the judge made his ruling, the judge really had to stop and said, Mr. Clinton, what this means is that you're going to go home today. I think that's the first it set in with him, and he's gone back. He was working here in Quincy. He got a job after he bonded out as a dishwasher at a local Kelly's restaurant, and did that. And as soon as he was released from jail, it's my understanding he went back to Michigan, where he's going to be living with his grandmother. Can't hear you. There you go.
Cameron is claiming that he asked him to stop multiple times.
Yeah, I know what Cameron's.
He was inside of her. Drew is saying this is not true. He's saying everything that happened that night was completely consensual.
Yes, what I'd invite you to do, and I wish you would, is take a look at the trial transcript of her testimony and see if Cameron, if she said that, because that's not correct. What she testified to is that she woke up.
Sorry to interrupt for a second.
Sure.
Could you just keep looking into the camera?
Sure, I'm sorry. What she testified to is that she didn't remember what happened or what went on in that room until she woke up, at least this is one of her versions, with a pillow over her face. And he was inside of her. And I think I asked her, but the argument is very simple. If an 18-year-old boy has sex with a 16-year-old girl, unprotected, that she agreed on, or stated, you find some semen. And 3 DNA experts using state-of-the-art technology, the A-Star, which is only the second time it was ever used in Illinois, they found no evidence, absolutely no evidence of DNA inside of her. The other thing is that when she gave her version of the account, they asked her to basically reenact what happened. This wasn't a couch, it was an old love seat. And she had a very difficult time doing it. There wasn't enough room on the couch to reenact it. But again, buy the transcript. It's there, or it's not there, I guess would be the best way to put it.
Drew, as you know, there's outrage about this. There's outrage about this judge's reversal. What does Drew say about that?
He's just grateful to be out, to be honest with you. I don't think he understands the magnitude of what's going on. I'm not even sure he appreciates it. He's just glad to be out of jail.
Obviously, he agrees with the judge's decision.
I mean, he appreciates the judge's decision. I'm not even sure he understands the judge's decision other than to let him out of jail. He is, he's 18 years old. He's not a sophisticated young man. He's never been involved in the criminal justice system. This was all completely foreign to him. Everything that happened, even trying to explain to him his rights to not have to testify, which he had to waive, was a difficult process. Not that he's stupid. It's just that he's a young teenager.
He maintains his innocence today.
Yes. He maintains it was consensual. He's always said that.
Does he have any regrets about that night?
My guess is everybody involved has regret about that night. They have regret about drinking. They have regret about getting drunk. They have regret about swimming in their underwear. They have regret that they didn't stay in the room with her. He has regret that he did stay in the room with her. I mean, one of the things that happened before they went into this room was they were out in the car for about a half an hour, and she was cold, and he gave her his sweatshirt. So everybody has regret about this. It's a sad situation, but I think that's kind of goes back to what Judge Adrian said. When adults don't exercise their responsibility, and when I'm talking about adults, I'm talking about the people who hosted the party, not her parents, but the people who hosted the party. When you let teenagers, bring alcohol to a party, and Cammie brought the alcohol. And when you furnish alcohol to teenagers at a party, and when they start taking off their clothes and swimming in their underwear and you don't stop them, good things are not going to happen. Bad things are going to happen, and that's what we have here. This whole situation was easily avoidable, but it happened.
So, Drew, you're saying that in the trial testimony, Cameron never said that she told him to stop multiple times, and he wouldn't, and she pushed him off of him, and
that she said that happened. She said that happened after she woke up. That she pushed him off. Afterwards, not before. And the issue is, did she consent? And again, her story makes no sense when you understand the DNA evidence. That's the problem that the state had. You basically have to ignore the DNA evidence. If you look at the motions that were filed by the state, there were 5 what I'll call rape shield motions that the state filed to protect this alleged victim. Judge Adrian granted every last one of those motions over my strong objection and tied my hands to a certain extent. And I'm not saying his ruling was wrong. I accept his ruling. But for anybody to say that he has victimized this young girl and didn't protect her, it's just wrong. He protected her as best he could, but he's still got to follow the law. And the law is the state has the burden of proof beyond a reasonable doubt, and they didn't come close to meeting it.
So tell me a little bit about sort of what a whirlwind the past week or two has been with regards to the case, and give me sort of a timeline of what happened from where you see things.
Well, whirlwind is probably an understatement. what happened is back in October we had a 3-day bench trial. My client Drew was accused of 3 different crimes. At the conclusion of the trial, after 3 days, after a lot of extensive testimony, including 3 DNA experts, Judge Adrian at a bench trial found him not guilty of the first 2 counts, and I think that was because of the DNA evidence that supported his situation or his finding of not guilty, and found him guilty of digital penetration, which was the 3rd count. After that, he sent him to jail, revoked his bond, sent him to jail, and I filed post-trial motions, which are a common occurrence. It's basically an avenue that the law allows me to point out to the court certain errors that were made or that I believe were made, and ask the court to reconsider its ruling. And that's what I did. I filed 2 post-trial motions. Those were set for hearing in early January, and we had the hearing. The judge denied my first motion, and with regard to the second motion, where I asked either for a new trial or for a finding of not guilty, because of certain reasons that I had argued to the court, the judge accepted my argument and reversed himself and found him not guilty of the 3rd count, and that's what initiated the firestorm of activity generated by the young lady and her family and a lot of advocates.
Totally, and in doing those 2 filings that sort of work towards the reversal, how rare is this to happen sort of in Illinois or in a case in general?
Well, I mean, I file them all the time. I would guess that just about every defense lawyer does. It's something you do. They are not routinely granted, but they are granted. You're asking a judge to admit that he made a mistake in his original ruling, or that the jury made a mistake in their original decision. So, that's a pretty big bite of the apple to do. And it's there just for cases like this, where, in retrospect and then standing back and looking at the evidence and looking at the law, this should have been the verdict. I maintained all along that all the court did was correct an error that originally made, but apparently that's what's caused the firestorm.
Totally, and just sort of, overarching themes too of the case. You and your client maintain that this was a consensual act, correct?
Correct.
That is not changed from the beginning?
Yeah, he's always said that. He was 18 years and 2 weeks when he was arrested. He doesn't have he has virtually no family support. He lives with his grandmother in Michigan, and he came down here to see his friends for graduation, to attend the party, and to play in a basketball tournament. When the police arrested him, I think he was somewhat dumbfounded. He went with the police. He was subject to a 3, 4, 5 hour interrogation. He didn't ask for family. He didn't ask for a lawyer. He waived all of his rights, and he told him what happened. I believe thinking that he hadn't done anything wrong. And what turned out to be a good thing for him, and parenthetically for me, is he told the truth. His story never changed. So when we went to trial and we evaluated whether or not he should testify, we made the somewhat risky decision, to let him testify and exposed him to cross-examination of a very experienced prosecutor. And my thought is, because he told the truth, and because he was telling the truth, and because the truth never changes, he was able to do that. And I think that's why we ended up with the ruling that we ended up with, which obviously I believe is correct.
Totally, and along those lines, as far as how many days that you served already, do you feel that justice was served in this case?
Well, that's a tough question to answer. And the reason I say that is because if he was guilty, no, I can't say that 5 months is enough. But the fact of the matter is, he was found not guilty, so 5 months is 5 months too much, because an innocent person should never go to jail. So that's the answer to that one. This isn't a situation where, this judge sentenced him to 5 months in jail. What the judge did was he revoked his bond after he found him guilty and sent him to jail because now he'd lost the presumption of innocence, and he was a convicted felon and he didn't want him on the streets, which happens all the time.
Totally, and you know, do you expect the state's attorney office to try to appeal this case since it is such an unusual ruling?
In Illinois law, the state can't appeal. It's over.
And have you spoken to your client about the media attention this is now getting? What do you guys think about it? What does he say?
Well, Drew Clinton is 18 years old. You know, and I've made this statement in the past. He's 18 going on 14. He's one of the most naive young men you've ever met. I don't know that he totally understands anything of what's going on other than he was in jail and he didn't like it and he felt that it was for something he didn't do. His family, which really consists of some distant aunts and uncles, I've spoken with them. They want him to be left alone. They want him to be able to get on with his life and put this behind him as, you know, we would hope everybody could.
Totally. And do you have any sense of what his plans are for the future? You know.
Well, I know what his plan had been. What he graduated early from high school, so he was only 17 when he graduated from high school. And his plan was to interview and apply for a job with UPS or Federal Express or somebody like that, because obviously there was a great demand for those people, and make a career of that. But he had to be 18 before he could apply, so that when he came down here, he had just turned 18. I hope that that's his plan for the future, because for him, that's a good plan. And, you know, hopefully this won't interfere with that.
Totally. And is there anything else that you think that you want us to get across, sort of, or any overarching themes or thoughts about the case, or what you want everyone to know about the case and your thoughts?
Well, a couple of things. One is, the judge that made this decision is an excellent judge. If you ask any defense attorney or any prosecutor, he's tough on crime, but he gives you a fair trial. And he's being attacked for victimizing this girl. He granted 5 pre-trial motions dealing with rape shield to prohibit me from attacking this girl as I would have liked to have done. So he did everything he could to protect her. My personal opinion, in whether it's this case or whether it's Kyle Rittenhausen or whoever it is, I think attempts to influence juries and judges by outside interference with the court system, whether it's picketing or whatever, while it's certainly allowable under the law, doesn't do the system any good. The decisions need to be made inside the courtroom, and people that are critical of those need to go to court and find out what they're talking about before they shoot off their mouth.